Good day, everyone. We're going to have some fun today. Let's get started. This is Digital Assets as Collateral, UCC Article 12, Episode 1 in the 3-episode series, Digital Assets in Commerce and Bankruptcy. The next episodes will be in the following months, one per month. You can read more about financial poise in the slide deck. Our panelists today, which is probably more important than that presently, are Tim Eisenberger of Adams and Reese and Jackson and Charlotte, James Sullivan of Seyfarth Shaw in New York City. I am Christopher Cahill of Dykema-Gossett in Chicago. You can see our names on slide 5. You can read our bios on slides 33 to 35. Neither Financial Poise nor any of us panelists intend for this to be an infomercial. So you won't have to listen to me read slides to you. If you want more information about us, just look at our bio slides. About the substantive slides, I'll try to call your attention to slides that are relevant to whatever we're talking about. So you can take notes if you like. Don't worry if you're listening but not watching this webinar. You'll be just fine because the slides are not critical. This is intended to be a conversation. We talk, we learn, you learn. Financial Poise webinars are supported in part by sponsors. The sponsors for this webinar are Sunburst Digital, maker of Type to Learn, the #1 typing app for children K through 12. Max Asset, if you need to conduct an online auction, Max Asset is your turnkey solution, which is sounds rather nice for a busy bankruptcy professional. They're described on slide 3. Mood, the nation's premier online retail cannabis dispensary. More on slide 2. It's a different world, man. That's all I gotta say. The last thing before we begin, you are not our clients. We are not your lawyers. We're all 3 lawyers, but we're not your lawyers. What we do today and what we say today is for your general education and not for you to act upon without appropriate advice from your lawyers. All right, here we go. James Sullivan. We're going to be talking about the UCC and its evolution, additions to it today. But what is the Uniform Commercial Code?
Thanks, Chris. Well, in just very high-level terms, the Uniform Commercial Code was a model law that was drafted with cooperation and partnership between the Uniform Law Commission and the American Law Institute. They came together in 1942, and by 1951, they had released the first model comprehensive uniform commercial code to be considered for enactment in all 50 states plus the District of Columbia and the U.S. Virgin Islands. The states slowly began to enact the Uniform Commercial Code. The first state to do it was Pennsylvania in 1953, and it took about 20 years for all 50 states to, and the District of Columbia and U.S. Virgin Islands to enact it in some form or other. The states had the ability to modify the model law before enacting it. In fact, Louisiana never adopted Article 2. So again, there is some variation from state to state. And periodically, as there are developments in the law, for example, the creation of these new digital assets that we're going to be talking about today. So recently, the Uniform Law Commission, American Law Institute, got together to decide what to do about it. And that's what we're going to be talking about.
Tim, would you like to put a gloss on that?
Yeah, so generally the idea is you want to encourage folks to do business across state lines and all over the United States. And one thing that can hamper that is if you have all 50 states with all kinds of various different laws enacted at different times, treating transactions differently, you're going to be kind of hesitant to go out there and finance things with people in other states and across borders. So the idea is you create one set of uniform laws and encourage every state to adopt that same code, which is the UCC. And by doing so, then people feel much more confident in transacting business all over the country because they know that their transactions should be and are supposed to be treated the same, no matter where they are or who they transact business with. And that's sort of just the general purpose of why the UCC exists and sort of the benefits it provides the business community.
Well, this UCC is necessitated because of federalism, because our 50 states have 50 different sovereignties, and they're generally in charge of their interior affairs, which includes commerce. I guess it hadn't occurred to me till just now to think that the process that James was describing and the seemingly arduous nature of it that Tim is, springing from. How do you get 50 different, animals into the same corral? It's not easy, no matter what kind of animals you have. But there's a great incentive, obviously, an economic incentive. There's far more wealth involved when you have a relatively uniform regime of state law. And the other thing I would say is, all the lawyers who are on this call had the UCC sitting there when they went to law school. But it didn't sprout fully formed from the brow of Zeus. James, you had some inside looks at what's cooking in this kitchen. Would you mind sharing with us your role and what you see in terms of, how this thing happens, so that we can fight about it and benefit from it ultimately?
Right. So I participated as an official observer to the most recent promulgation of Article 12. But obviously, there's a permanent editorial board that has been working on this for years, and the board is largely consisting of lawyers who are experts in the field, professors at universities and the like. So as there a need for changes to the Uniform Commercial Code pop up, there's debate about it. Obviously, crypto assets and digital assets have been around for a while, so it takes quite a bit of time to first recognize the need to modify the Uniform Commercial Code, and then to actually draft it and in a way that makes sense. In fact, it's interesting, just an interesting story. An earlier draft of Article 12 had been released for comment, and Wyoming, which was at the time trying to get ahead of some of the other states and become a leader in order to attract crypto businesses to Wyoming and to incorporate there, they actually came out with their own law before Article 12 really came out. And so they actually sent a letter to the Uniform Law Commission and the ABI, to American Law Institute, to tell them why they thought that the draft had been released wasn't good enough and all the mistakes associated with it. So, and then the drafters of Article 12 said, yeah, okay, you made some good points there. So then they kind of took it back and they started, making some revisions, and that's what you have here today. But interestingly, a few states actually passed the prior version of Article 12, right? So they wanted to get ahead because, again, a lot of the time, one of the reasons why the code comes out and it gets adopted is states want to get ahead of the other states, right? Because then there's a race to become the leading jurisdiction to deal with these assets, and they're hoping that business will flow to that state as a result. So it's just kind of interesting how these things kind of evolve and whatnot.
So avarice, ingenuity, and then uniformity. It sounds like some kind of spiritual process or something. But I mean, I guess we should, just as an aside, we'll move on from this. be kind of grateful that we have a UCC at all. And we'll see how this process works out. I think you've just already answered the next question I was going to ask, which is why use UCC. Just describing what it is answers the why. So what is Article 12, Tim? If somebody, another lawyer says, hey, what's this Article 12 thing? And you have, 5 minutes to respond or less, what would you say?
Well, I would say that, with the rise of cryptocurrency, particularly Bitcoin, which came about in 2008, and then we saw it rapidly grew in popularity and value, it became apparent that, if something's got value, people are going to want to use it in their financial transactions, use it as collateral, but it didn't really fit well with the pre-Article 12 UCC. Digital assets are technically general intangibles under the UCC.
A type of good? Is that what a general intangible is? One of several
Yes.
different, they're phenotypes of goods, right? To use a biological.
Yes. So, yes, and you can perfect a security interest in a general intangible by filing a UCC financing statement in the state where the general intangible is located. Now, when it comes to cryptocurrency, though, that doesn't really do you much good, because when there's a default, you obviously want to foreclose on your collateral. And take Bitcoin, for example. If I've, pledged my Bitcoin as collateral and they filed a UCC financing statement in the state I live in, they have no idea what I've done with that Bitcoin. I could have traded it away to somebody else on the blockchain network, who then traded away to somebody else. I could have liquidated it. It could be owned by somebody on the other side of the planet. And, they had that financing statement filed, but it didn't do them any good because now it's time to foreclose and they have no idea where to get it. Think about the other shoe. If you take a security interest in a large piece of construction equipment, that's hard to move. It's hard to hide. So when somebody defaults, it's pretty easy to go out there and find it and foreclose on it. And if you can't find it, you can usually get law enforcement to go out, whether it's a replevant action or whatever, to go take it back. Bitcoin and crypto, other crypto assets do not work like that. So with that problem in mind, the drafters of the Uniform Commercial Code came up with Article 12 to create a subset of digital assets called controllable electronic records, which, instead of filing a financing statement to perfect, which you can still do, you can now perfect your security interest by controlling the electronic record or the cryptocurrency. And that is the Article 12 had a few features, but that was the fundamental feature. Find a way to allow lenders to perfect security interests in these crypto assets through controlling them. That way, your borrower can't abscond with them, can't liquidate them and trade them away. You've got control. You're able to foreclose better.
Yeah, Bitcoin. How many were used to buy that legendary pizza, or 2 pizzas? Some number. Now, what would that be worth now?
I think it was
$400 million pizzas or something.
Yeah, it was $40 worth of Bitcoin, and the amount that was at the time is now worth, I think, like over 50 million. And that was when I last calculated that at 50 million. That was before Bitcoin rose to its current price of like $60,000 per Bitcoin. So, that just shows how much it exploded in value, and it's still got a tremendous value compared to when it was first released back around 2008.
And so we're back to uniform law that allows financial actors, which is everybody at one remove or at the same remove, to deploy digital assets as collateral for loans, enables capital to do its virtuous work out there. And more orderly financing if it's also done nationally. And kind of has to be done nationally because this stuff doesn't just stay in one place. They're like subatomic particles, you know, they just keep moving. And hence Article 12, right? I mean, James, is there any color you want to put to that before we get to how this works?
Yeah, so one of the fatal flaws under trying to use existing law to govern the perfection and transferability of digital records, such as crypto, is that there really wasn't a neat category to place these in. So again, as Tim said, they were people sort of like said, well, there's really no good place to categorize it. So the catch-all area was digital. Intangible goods, right? Intangible assets.
Yeah.
So, and how do you perfect a security interest in that? Like Tim said, you use a UCC 1 financing statement. How do you release a lien on a intangible asset? You need to actually sign a release. And when people are trading crypto, no one is signing releases of liens in connection with that. So anyone with a blanket UCC lien against somebody's assets, that lien is probably still attached to the crypto that the borrower or the debtor traded. And because all these transactions are on the blockchain, right? In theory, might be difficult, but in theory, you could trace the crypto, and then all the crypto that's been trading out there probably has all these unreleased liens, these UCC liens that are attached to it, right? So it's really like a wild west of situation where you're not really sure what you have. And so it really, this case, like I remember looking into this way back when Bitcoin was worth trading for less than $1,000. Thinking, should I invest in this? You know, kind of did a little bit research into it. And I'm like, this is nuts. And like, why would anybody ever want this stuff? You never know. Somebody could come along later and say, look, I have a lien on it. It's mine. And legally speaking, I think they'd be right. So, but, you know, in theory, you know, I was sort of like looking at some of these big bankruptcy cases involving these crypto exchanges, and I was waiting for somebody to come forward in one of those cases, and I was hoping they'd hire me to do it. But I was waiting for somebody to come forward and say, you know, that millions and millions of dollars worth of crypto, I know you guys are fighting about it, but I actually have a lien on it. And I think the amazing thing about Article 12 is it's really largely intended to eliminate that fatal flaw with the existing system, so that people could they know based upon these rules who has rights to that crypto asset. Because right now we don't really know. You know, it's really is a Wild West situation going on right now.
And so many times lenders take an all asset lien, and little did they know that they were taking an all asset lien that covered this property. And so if you have a company that you know is availing itself of credit over a period of time, you know, many times, each of those times it's been encumbering its digital assets, and you know, and the same digital asset goes somewhere else, it gets encumbered. Maybe it was encumbered before you got it. Oh, that's a tiresome mess. And so for this stuff to really become important financially and generate more wealth for everybody, you know, directly or indirectly, we need to get lassos on this thing.
And one of the purpose of cryptocurrency, particularly Bitcoin, was it was not supposed to be some, you know, asset that you invest in and make tons of money off of, which is what people are doing now and people have done recently. But the purpose of it was supposed to replace fiat currency. It was supposed to be money, and you were just supposed to use it to buy and sell on the internet. And so if you've got the issue that James was talking about, where all of this circulating cryptocurrency, which is supposed to be money, has liens on it, and you don't know, when you're taking Bitcoin from somebody, you don't really know what you're getting. That defeats the purpose of Bitcoin itself. It's not as negotiable as it's supposed to be. So that's another reason for trying to replace the UCC 1 perfection method with control, because that way, when the lender has control over the asset, it can't be traded off, through the system, and then who knows where it's gone, and the recipient has no idea what kind of liens are attached to it. So it was simultaneously to help
close that
encourage.
loop. If you take a security interest in cash, you perfect it by
Possession or control, yeah.
exactly.
Yep.
So that loop is perfect. But you were going to say in addition to.
Oh yeah, that's exactly the point. It was.
Yeah.
Okay.
Sorry, I
it
jumped
not
off.
only fixes those problems, but it actually helps promote the purpose of cryptocurrency, what it was actually supposed to be for in the first place.
All right. Tim, let's talk about controllable electronic records, an important denomination within Article 12. That in a few years will just be, every fifth panel at every national lawyers gathering will be talking about controllable electronic records. And this ties right in what we were just talking about. So please describe this innovation that James's friends at the at the body that came up with this derived.
Yeah. So the term digital assets is actually like incredibly broad, and it can include cryptocurrency, and it can include NFTs. And what people tend to think of when they hear the term digital assets nowadays, but it actually can include websites. It can include your social media accounts, your Instagram account, your Twitter account. So what Article 12 did was, in the whole world of what could be considered a digital asset, it created a subset, and it was called controllable electronic records, which kind of sounds vague and broad, but it was kind of intended to be. But basically, what it covers is, it covers those electronic records that a lender would have the ability to control. That way, you can actually control, perfect your security interest by controlling it. So it's a subset of digital assets. CERs is what the abbreviation is, controllable electronic record. It's a subset of digital assets. And it's digital assets that you can actually control and exclude other people from enjoying the benefits of. And that's how Article 12 defines it. It's, I think, Section 12102A1. CRE is a record stored in electronic medium that can be subjected to control. So then the question becomes, well, how do you actually control it? And Article 12 answers that too. That's Section 12105A. And it says, control exists when a secured party can derive substantially all the benefit from the CER. The secured party has the exclusive power to prevent others from availing themselves of substantially all of the benefit from the CER. And the CER allows the holder, the secured party, readily to identify itself in any way, including by cryptographic key, as having these powers. The general idea is that if you're going to take control of the asset, your borrower or your debtor can't go off and trade it away and you never see it again. If there is some method, if it's Bitcoin, you can hold it in, the lender can hold it in its own cold wallet, or it can have a special escrow company hold it in the escrow company's wallet. But by doing so, you then control the benefits of the CER to the exclusion of your debtor. That way, it can't dissipate. And the language of the definition is broad because it was meant to not just apply just to Bitcoin, but it was meant to encompass cryptocurrencies and NFTs and other digital assets that we know of today, but also to encompass those that might come tomorrow or a few years down the line. So as long as you have some way to control the asset and it meets the definition in Article 12105A, you then have a controllable electronic record that will be subject to Article 12.
Well, here's a note to those listening that CER is a very central definition, central concept, and it is discussed on slides 17 through 21 of our slide deck. That's how important it is. But I'm going to go off this rail for a moment. By the way, everything you just said about control, again, goes right back to the money example. If you're using money as a having a security interest in money, you must have control similarly, because money can go and you don't know where it goes. Although it doesn't go in like a millisecond, you actually have to go somewhere and spend it, or at least enter it into a contract and send it electronically. But it can go quickly. So that's that's the approach, and CER is essential to it. I guess then we should move on to. Let's step back for just a second, having articulated that, and go right back, because there's something that people should know about. James, or Tim, pardon me, where do we stand on adoption of Article 12? How many states have adopted it, rejected it? How many are in process? They're concerned we won't get to all 50. And what happens if it doesn't? Let each state adopt it before it's effective for any?
So as we stand, as I've actually checked the statistics this morning, it's been enacted in 17 states, which I found was surprising. I thought that was a lot, given it's kind of a cryptocurrency and everything is kind of a unique niche area. But it's been enacted in Alabama, California, Colorado, Delaware, DC, Hawaii, Indiana, Iowa, Kentucky, Nebraska, Nevada, New Hampshire, New Mexico, North Dakota, South Dakota, Virginia, and Washington. And I know some of those states are rural states, so they might be kind of out there trying to attract business to them, and that's why they went after it. I'm located in Mississippi, so it surprised me that Alabama's enacted it. I suspect it will be a while before Mississippi does. And it's also been introduced into 13 states. So I feel like it's off to a pretty good start. I feel like to get all 50 is going to take a while, just because you have some states like Mississippi where it's not really on the top of the state legislature's mind. And we don't necessarily have crypto businesses that are going to be out there hiring lobbyists to kind of push the legislation along. And then, like James was saying, you've got some states like Wyoming where they went off and did their own thing first, and they might stick with that for a while. So it does seem like things are moving along quicker than I anticipated, but to get to all 50, I think will take probably some significant time.
Again, more push and pull before we get to the uniformity. But enough on that theme. James, I wanted to pick up on something that Tim alluded to. Okay, we understand that dollars are dollars, so you need to possess them. And we understand that you can use a dollar to buy. When you have a dollar, you have that dollar physically, or even in your checking account, it's yours. Nobody else has rights to it. And you might say the same about, a CER. In fact, that might be an essential quality of a CER. And I'm saying that because Tim mentioned NFTs. And I was just reading a brilliant article from 2021 about NFTs and how they kind of fall short of something you really own all of. Because if you think about NFT as an image, that you buy, now you have some rights in it, but not all rights. Is that something you're familiar with, James?
Well, I mean, I think what you're alluding to is the fact that oftentimes NFTs have other rights tethered to it, right? So the NFT that would be, for the most part, governed by Article 12 is the document or the record itself, right? The electronic record of it, not necessarily all the rights tethered to it. So, for example, if there was an NFT that gave the holder of the NFT the right to some payments or the right to it could be virtually anything, really. Yeah. It doesn't necessarily give the holder the other rights. For example, if the NFT was some artwork, right, it doesn't necessarily mean that they hold a copyright to that artwork, and it doesn't necessarily mean that duplicate copies of that artwork, could still exist out there. All it gives you is the right to the exclusive ability to control that specific digital formulation of the artwork, let's say. So, in the last couple of years, NFTs were very popular for a while. I think they've kind of fallen off a little bit. They're not quite as valuable. In fact, probably most of them out there are probably like almost valueless at this point in time. But, there could be a resurgence in the future. We'll have to see what happens with those. And one of the things that I wanted to kind of mention, Chris, when what Tim was kind of saying before, kind of reminded me of it.
Yeah.
When he was talking about control, was how do you demonstrate control? Like, practically speaking, how do you demonstrate control, right? And the easiest way to demonstrate control is to actually transfer it, right? Because if you're able to transfer it, then you've sort of satisfied all the tests. Even in fact, for example, if you've hacked the system or somehow stolen somebody's crypto password, cryptographic password, private password, you could also exhibit control. And so one of the interesting things that Article 12 does is it allows somebody who maybe has stolen these crypto types of assets, virtual assets, to transfer better title to the assets than it had the right to convey, right? Pursuant to the take free rules, which is very similar to like a negotiable instrument, right? So like a good faith purchaser for value of the asset, right? If they had no notice of the wrongful nature of the transfer's rights, right? Gets good title. And so it's pretty interesting. And so that's one of the, we'll probably get into that in a little bit, but I was sort of getting a little bit ahead of myself. But, going back to the control feature, what most lenders will probably do to show, like, to kind of prove that it fits within the definition of a controllable electronic record is to say, okay, transfer the asset to an intermediary, let's say, because you may not want to necessarily transfer it to the lender, but transfer it to an independent intermediary, similar to the way like Article 8 works with respect to certificated securities, right? Some independent third party will hold it, and the way that will work is that there'll be multiple private keys, right? So like in order to be able to transfer it, you would need to have more than one password, if you will, right? So in order to be able to transfer it. And so this whole industry is going to end up being created, this intermediary industry. I'm guessing that a lot of...
You should invest in that,
Yeah, seriously.
Necessarily.
My guess is a lot of banks will probably undertake this. They'll probably, because they're already sort of like well suited for it. But, it's possible that other parties could serve a similar function.
Yeah. Maybe, the parties that hold assets for pension funds and such. I won't scare anybody, but at some point, CERs are going to become so mature and more predictable in value, because not everything is Bitcoin or even Ethereum, that, they'll fit well with fiduciaries of assets held for, retirement purposes and such. All right, so you were talking, James, about take free. I mean, that's what we do every time we buy something from the store. Every time we buy a car, every time we buy something where you as consumers or as business people, you're taking free of whatever security interest was in it. And just wanted to bring that down to the earth for everybody who's listening. And so we're trying to make that, or the part of Article 12 is to make that possible. In fact, that's a key part, wouldn't you say, James?
Yeah. So what Article 12 does is it allows consumers, if you will, to trade these digital assets, these controllable electronic records, without having to check the UCC lien searches, right? They're not going to have to do a UCC lien search, for example, every time they want to take title to a good. So it's similar to the way that goods are transferred in the ordinary course of business, that you could acquire that without having to, get a lien release. That's the way that the UCC currently works with respect to that class of asset and other types of assets. But unfortunately, with intangible assets, you do need you need to get sign release, and that's just not practical when we're dealing with crypto assets.
But we could, Tim, just going along this line a little creatively, have tokens. Not talking about NFT tokens, for real tokens, like a title for a car is usually a physical object that you have the cars, which you could sign over to somebody and actually get the car. So they're tied together intimately. But you could have tokens, and this will be the subject of a future webinar in this series, for real estate, which after all, we already have tokens for them, but these would be non-fungible tokens, electronically created. You could have that, and you could have tokens for equity shares. James brought up Article 8 of the UCC. This would transform Article 8, perhaps. And we could, and that could, and so then the context of having these as tokens, which qualify as CERs, and the people receiving the tokens through the transactions are qualified then as, what's the term?
Intermediary under Article 8, is that what you're referring to?
No, I'm not referring to Article 8, I'm referring to the article.
Qualified purchaser, is that what you're talking about?
Qualified purchaser, precisely. So this could open up a lot of different kinds of commerce, which you can all do in your homes and never see anybody or talk to anybody ever again, but manage a large portfolio of assets.
Well, I mean, there are carve-outs in Article 12, right? So where other provisions of Article 9 apply, then this would not be deemed to apply, right? And the Uniform Commercial Code is not really intended to at least deal with transfers of real property. So I'm not sure whether that would be covered, but there's exceptions for like electronic chattel paper. So even if like there's existing UCC provisions that deal, for example, with chattel paper and documents and investment property,
which could themselves deal with real property.
Right. So the fact that these forms of assets are evidenced in an electronic form doesn't necessarily take it out of those other sections of the Uniform Commercial Code. Those other sections of the Uniform Commercial Code could still apply, and the new Article 12 and the other amendments sort of touch upon that there are carve-outs for asset classes that are already addressed by the other provisions of the Uniform Commercial Code. So that'd be, it'll probably take a little while before it's sort of like you find exactly where those lines are drawn and figure, okay, does this, the fact that this is a digital representation of an asset that would have otherwise been governed by another section of the Uniform Commercial Code, like how do we define that? And then there's also, there's also nothing stopping parties from opting into Article 8, right? That Article 8 is broad enough to allow parties to have an asset that's not a financial asset be deemed a financial asset for purposes of Article 8. And so, that's even something that could be done now, that you could use an intermediary to control an asset. Maybe you don't want to wait until your state has enacted Article 12. Maybe you want the benefits of being able to control that now. And so you could opt into Article 8. So that's always a possibility as well. So, there's going to be a lot of, until there's some uniformity, right? That's the ultimate goal here, is to have uniformity, until there actually is, because enough states have adopted it and parties have kind of figured out where the lines are. There's going to be a little bit of growing pains, and we're going to have to kind of like learn this together and figure out how to do some workarounds.
I want to make this comment and throw it over to Tim. What you're illustrating, I think, James, is the nature of the Uniform Commercial Code itself, just to circle back and try to unify the discussion. So it's not just about this, that, and the other, but about the whole thing. In that the Uniform Commercial Code doesn't exclude other arrangements that parties choose to agree on. You can be very creative with your own transaction, And the Uniform Commercial Code need not necessarily apply. It just needs to be the kind of contract that can be enforced and so forth. So the Uniform Commercial Code isn't a waffle iron on the 50 states. It's a set of principles that will apply if you don't, supply all the terms of your contract. When it's a contract and the sort of things the Uniform Commercial Code covers. So the Uniform Commercial Code is not a universal and omnipresent law, I guess I was trying to suggest, or rather a universal and available set of default laws, as well as laws that many contracts expressly draw on. And that's, to me, an interesting thing, which also might account, Tim, for why Article 12 is so brief, right?
Yeah, I mean, yeah, the Uniform Commercial Code is intended to be like gap filler. So you can design your contract and customize it any way you want. And if you happen to not cover something specific, the UCC can then supplement and will solve whatever that gap was. And Article 12 is so brief. I mean, it's only 7 sections long. And so it's not overly complicated. It's pretty basic. It's trying to solve a simple problem. Well, I guess we'll actually, it's like what James was suggesting. I guess when we actually see this litigated in court, we'll actually see what the problems are and where the borders are. But that's kind of where we are right now.
Okay, I'd like to get a little technical then about digital assets functioning as collateral for secured credit. Tim and James, I'd like you guys to talk about this. It seems like I'm going to throw out a hypothetical, which I know is wrong, but I want the panelists to explain why it's wrong, to put a little meat on the bones of what can be a discussion of intangibles, not in the technical sense, but just stuff you can't see, feel, or touch, such as digital assets. So much of what we're talking about is control, which is a possessory almost thing, and controlled by this means or that. So how is a secured creditor who would have control over the controllable electronic records distinct from a pawn shop, which I'll point out, the pawn shop owner has control literally over every item in there and will not give you your trumpet back unless you pay the loan. So they got control over that collateral. So Tim, why don't you start distinguishing a pawn shop from a secured party in a secured transaction under Article 12?
So I think it's what you were suggesting, Chris. It's that in the real world, if I go down the street with my trumpet and I want to pawn it, they're going to take physical possession of the trumpet. You can't do that with digital assets. And so that's why the definition of control under Article 12 is a little broad, because it's got to try to take into account how control works on the blockchain and with NFTs and the digital assets, because it's not the same. You can't actually physically hold it in your hands. Even when we talk about cryptocurrency like Bitcoin, we often talk about keeping it in a wallet. The wallet, it's the term for it, but it's not really an actual wallet that the Bitcoin goes into and that you hold it. They call it a wallet, but really all it is it's a private key and a public key. And you use the public key to receive Bitcoin from somebody else. And the transaction is actually recorded on the blockchain ledger, which is decentralized all over the world.
So let me interrupt you just for people who are neophytes when it comes to blockchain.
Yes.
We can send files all around with our computers all the time, but they're fundamentally distinct from sending a digital asset, especially like cryptocurrency, that's recorded on a blockchain. And what are those qualities that are really key to BTC being a CER? Let's talk in terms of just acronyms like that for the rest of this talk. No, I'm kidding. But what would be the distinction? explain it a little more amply.
Well, so the blockchain is, I like to think of it as just, it's like a bank's ledger at the physical bank, except it exists on a computer system that is decentralized, which means it's not just on one person's computer, where if I've got the ledger, I'm the one that keeps track of everything, and it can always be found on my one computer. Decentralized means it exists on a network of computers all over the world. For folks that are my age, you might think of Napster or LimeWire, where that was the computer software where you could download whatever music you wanted. Though that software existed, it was decentralized. So when I went to go download music from Napster or LimeWire or somewhere like that, I wasn't downloading it from one computer somewhere. I was downloading it from someone else's computer all over. It could be anywhere in the world. And if they happen to shut off their computer, I can start downloading from somebody else and somebody else. It's decentralized. So it exists simultaneously on everybody's computer. The blockchain is like a bank's ledger that operates the same way on multiple computers on a network all over the globe. And when you transact on the ledger, all of these people that are operating the network, which they call nodes, they're basically just volunteers out there, operating the network. They race and they verify it to make sure that it's accurate. And then it records all of the transactions all the time that are happening. And that's kind of how Bitcoin generally works.
Well, I want to throw it over then to you, James. How does a feature of Bitcoin make digital assets that are, tied to the Bitcoin, not Cato money, which is might be called digital, but it's really not a digital asset. It's just a file I'm using to, demean our currency. Rather, how does the nature of blockchain as a holder and transmitter and recorder of these transactions lend it to the CER notion, as well as the qualified purchaser notion?
Right. So, like what Tim was saying, there's a public key and a private key. So with the private key allows, it doesn't really need to be, the public key, anybody can get it, it just allows you to receive it. But the private key, it's very, there's a mathematical models. It's like, you would have to do like a really, really hard math problem in order to be able to try to crack the private key. Pretty much impossible. Like, the cryptography has advanced to amazing levels. And the way that the blockchain works with respect to crypto assets, it takes advantage of these advances in cryptography. So the way that it works in terms of exhibiting control and the use of intermediaries is that you can actually have, and Article 12 actually says this, that you can actually have more than one private key and still maintain sufficient exclusive control for purposes of qualifying as a controllable electronic record. And the way that would work in context, like I could own, let's say, some Bitcoin with you, and we could, in order to be able to transfer that Bitcoin, the way that it could be set up is we both would need to have the private key. We both have to authorize the transaction. It's kind of like a two-signer check, right? The way that that's set up is both of us would have to consent to the transfer. And the way that it would work with respect to an intermediary, it would probably take advantage of this two-signer or multi-signer context. Maybe you would require the debtor and the lender. Maybe it would require just the intermediary as well. So there's ways to set it up with multiple signers in order to make sure that adequate control is established, so that the crypto asset can't be transferred before the lender is able to realize value from its collateral.
Yeah, I was thinking of a situation very simple, and I may have mentioned it earlier, in which you would have more than one private key holder. Let's just go right back to the token by which you own a home or a car. And let's say it's an electronic token, a non-fungible token, which is to which the lender has rights under certain circumstances, and which the borrower has rights under certain circumstances, and you code all that. But you have each of them with a private key that enables them to control or even take total control of the CER, which is what the token is, the deed, or the title. That would be a situation where you would, I mean, this could support secured credit when it comes to, in fact, it might even be essential for secured credit. And then, you know, if there's some dispute over whether the loan is paid or whether there's been a default, then you take that to court. But meanwhile, each party has control over this token, and it can't be taken except in compliance with the coding that was accomplished pursuant to the contract. Is that a plausible scenario?
Well, I mean, I think from the purposes of, like, if you're dealing with real estate, you know, it may be binding as between the two parties, but if other parties get liens on the real estate using traditional state real estate law, I don't think
Right.
it would necessarily prevent that. So I don't know if that's a practical way just yet. You know, I think the states would probably have to buy into that concept of utilizing tokens to memorialize land record transactions, you know? So I think it'll be a while before we get to that level. So I think we still have to kind of take a step back and look at it from the perspective of, does what you're proposing comport with existing law? And if there were ever a dispute about it, like, how would the courts view it and address it? So, you know, I think in your context, you know, it sounds interesting, right? But if we're actually talking about real property, you know, Article 12 is not intended in any way to supplant real property law, state real property law.
No.
So
Do we?
if you wanted to have a house on like some digital world, you know, like these, you know, a lot of these video games, right? You can kind of go into this virtual world.
Yeah.
And buy real estate on there, like Farmville or whatever. You could probably address it as part of that. But, you know, an actual house that somebody lives in, I think we're still living in a world where, you know, state real property law still governs.
And maybe that's for the best. Speaking of courts, all right, so you're in one state in which the model law has been adopted, and somebody else is in another state in which the model law is adopted. You know, there are going to be differences, different quality of judges, you know, perception, different judicial attitudes. Maybe judges will understand it better in one case state where there's more of this activity than in another. So where will suits be brought? And maybe this is a dumb question because nothing about this changes where suits will be brought. Tim.
Yeah, so no state has, I mean, Wyoming tried, but no state yet has really, you know, garnered litigation over Article 12 because it's brand new. The courts that have the most experience with cryptocurrency, just generally speaking, are the bankruptcy courts in the Southern District of New York and elsewhere that have dealt with the cryptocurrency exchanges filed for bankruptcy. And they have not been dealing with secure transactions. They've just been dealing with ownership issues of cryptocurrency, which comes down to contract law. What do the terms of service say? Those courts are the most sophisticated in cryptocurrency right now. And outside of that, there really aren't any that have been dealing with it. So I suspect if there is a lender out there that becomes popular as one of the first intermediaries and they're putting choice of law provisions in their contracts and they have to start suing borrowers or there's litigation, whatever jurisdiction that is that they choose might end up becoming the jurisdiction that promulgates the most law on the issue. But right now, I'm not sure we have one. There are choice of law rules in Article 12. And I think they actually provide that the law that will apply will be where the CER is located. But of course, with controllable electronic records, it can be located, you know, multiple places at once. So If there isn't a specific location of the CER, then it falls to the jurisdiction the CER is expressly stated to be governed. So if there's something in the code or something about that network that says, X law applies, X law applies. Then if there's no governing law over the CER or where the system is located, then the CER is deemed to be located in the District of Columbia, and the District of Columbia law will apply. So maybe DC becomes the place where people go to file their lawsuits. But I guess I don't know. I think we're still at the very beginning stages, and I guess we'll find out eventually.
Well, James, you practice in New York, and when I was in law school, one of the judicial names that came up all the time was Judge Rakoff, who's still on the bench. 28 years later. How's he doing? How's the New York bench and bar doing with understanding these kinds of things? I mean, to the extent you can get any sense of that at all at this point.
Yeah, I mean, look, the New York courts, the way that under New York law, right? New York law was intentionally drafted to allow parties to bring their legal disputes to New York, regardless of the party's connection to the state. So that's been built into the New York general obligation law. So I assume that will still be the case with respect to disputes surrounding Article 12. And so, I think it will probably be a natural place for people to bring suits, but I don't think it, I don't think Article 12 was intended to force people to litigate in any particular jurisdiction. I think the more interesting question to me, like you had mentioned, well, you're assuming sort of that both parties to the transaction are in a state that has adopted Article 12. I think where it might be more interesting, at least in the short term, is, well, what happens if one party is in an Article 12 state, another party is not? Like, for example, an Article 12 state will honor the choice of law rules that Tim was talking about, right? Where, first you go to what does the CER say, then the protocol, and then maybe DC. But if I'm in a state that has not adopted Article 12, that state may say, look, our law applies, right? We think our law applies. So until, choice of law rules are always pretty tricky, even when the states are operating under the common law. So when they're operating under different laws altogether, it gets even more tricky. But, my answer to that would be, look, we've been operating under rules for the last 20 plus years when it deals with these crypto assets. It's been a Wild West situation. Crypto is still here. It hasn't gone away as a result of not having these rules in place and having any certainty. So I don't think it's going to go away in the next 20 years while some of these issues get worked out. I think we'll just have to kind of deal with the growing pains, work it out. And I think, if we have this conversation 20 years from now, hopefully there's a little bit more certainty in the world than there is today.
Well, go ahead, Tim, and then
I was just going to say to the early adopters of cryptocurrency, the lack of rules and regulations was a feature. So
That's right.
Probably still will be moving forward.
Some people enjoyed the Wild West, right? And some people flourished. I guess I would say in closing that lawyers, good lawyers, of course, always pay close attention to their conflicts of law and forum provisions in contracts. But sometimes those things are not looked at carefully. It seems to me that in this interim period, it would pay to look at things carefully. It might be even outcome determinative. Well, I want to thank you, gentlemen. Thank you, Tim Eisenberger, and thank you, James Sullivan. This somewhat preliminary discussion, which may mature over the next couple of years, has been a pleasure for me, and I hope a pleasure for the audience. Thank you, gentlemen.
Thank you, Chris.
Thank you.
And with that, so long to the audience. May everybody have a great rest of your spring. Thanks. Bye-bye.